America's center of power changed, and with it, the dynamics of the political landscape. The consequences will reverberate locally, in Florida, on Capitol Hill, and on the global stage. Voters demanded change on the issues that mattered most: the economy, immigration, and social issues. Now, News 4 Jax goes beyond the headlines with political analysts who provide unique context and perspective. Experts focused on the issues making headlines. This is Politics and Power.
And ahead on Politics and Power, the Supreme Court justices hearing arguments in some high-profile cases. First, a case that comes amid the DEI backlash. The nation's high court will review standards for groups that historically have not experienced discrimination. Then, can gun makers be shielded from lawsuits when the weapons they manufacture are used in crimes? And the third case on the docket, wrestling with the nation's frustrating search for nuclear waste storage. Questions about health risks and complicated politics have gotten in the way of addressing the problem since the advent of nuclear power last century. Welcome to this edition of Politics and Power. Bruce Hamilton, and joining me, constitutional law expert Rod Sullivan. Thanks for being here.
Oh, my pleasure, Bruce.
So let's start with this case. It has to do with reverse discrimination. The justices will review standards for groups that historically have not experienced discrimination. The case has to do with Marlene Ames, a straight woman. What's her argument? At the heart of this case is Title VII of the Civil Rights Act of 1964. It prohibits employment discrimination based on race, color, religion, sex, or national origin. It applies to all aspects of employment, including hiring, firing, pay, and job training, Rod.
Yeah. She has an interesting case. I mean, Marlene Ames had been in Ohio government for 30 years. She managed something called the Prison Rape Elimination Project, which is funded by the federal government but operated by the state of Ohio. And she'd been doing that for, 7 or 8 years. And she got a new manager. And her new manager was an African-American lesbian woman. In her first performance review, this manager gave her pretty bad performance review. Then a couple of months later, the job was put up to somebody else. And this African-American lesbian woman hired a 25-year-old homosexual man who was very active in the gay community in Cincinnati. And so she felt she was discriminated against based upon the fact that she was heterosexual and this man was gay and that her manager was gay. But she didn't bring a lawsuit at that time. She then put in for another job to be hired by the same manager, and the manager hired a lesbian woman for that job. So she said, well, look, I'm being discriminated against because of my heterosexuality. And she got demoted, by the way. Her pay was cut in half as a result of these two job actions. So she hired an attorney. She went before the Equal Employment Opportunity Commission. They said, okay, you've got enough to bring a case. She brought the case, and it went to the United States District Court in Cincinnati. And the court in Cincinnati says, look, there's a split in the circuits. Half of the circuits say that heterosexuals who claim discrimination are treated the exact same as homosexuals. And the other split is, no, heterosexuals, you got to prove more. You have to prove something called background circumstances, or you have to have direct evidence that you were discriminated against based upon your heterosexual. Now, you have circumstantial evidence, you have a suspicion, but nobody actually said you're not being hired because you're heterosexual. Nobody actually said we have a quota of homosexuals or quota for African Americans or whatever it may be to hire in this position. And since she didn't have that direct evidence, he said, I'm dismissing your suit on something called summary judgment. You're not even going to go to trial. I've looked at your affidavits, I've looked at your complaint, you're out of here. In our circuit, you need to prove special circumstances. So it went up to the Sixth Circuit Court of Appeals in Cincinnati, and they said, yeah, we're one of those courts that say that we don't treat heterosexuals and homosexuals the same when it comes to discrimination. If you're heterosexual, you need to prove more. You need to prove background circumstances. You need to have direct evidence that the reason you weren't hired or the reason you were fired was because of your sexual orientation. So that's the issue that went to the Supreme Court. Now, the argument in the Supreme Court really went bad for the state of Ohio, because the Solicitor General of the United States came in and said, no, we don't think this is right. We think there ought to be one standard all across the country. Nobody has to prove background circumstances. Anybody can submit evidence of indirect evidence and prevail and go to at least get a fact finder, get a decision. And so that was the Solicitor General's opinion, and that was the plaintiff's opinion. And the Ohio court, the Ohio attorneys representing the state of Ohio, I think saw the writing on the wall. And they said, you know, that's probably right. There ought to be one standard. There shouldn't be different standards for heterosexuals and homosexuals. So the outcome of this case seems foregone, like a foregone conclusion. If all of the parties before the court are saying to the Supreme Court, there needs to be one standard, everybody submits the same evidence, and then the fact finder decides whether or not there's been reverse discrimination or not, I don't see any justice coming down on the other side of that issue.
All right, so let me back up a little bit, because the one thing that I don't hear is that she had a poor performance review. That doesn't play into all of this?
Yeah, no, it will. So there's no guarantee that Miss Ames is going to win when she eventually goes to trial. The question is, does she get a chance to go to trial? And, you know, the fact is she had a really, it wasn't a bad performance review, but it was one of those distinctly mediocre. You meet expectations, you're getting by, so on and so forth. And the other thing is that, you know, this is for a position as prison rape elimination administrator. There could be an argument made, maybe a gay man would be better at handling prison rape elimination. So there are a lot of issues when this case finally goes, if this case finally goes to trial, but she didn't get to that point. She got bounced out even before she got to put on her first witness. And so that's what the issue is. Now, the argument on the other side is, the argument was originally based, and this has been around for a long time, this doctrine, is that while people in the majority discriminate against people in the minority all the time, people in the minority never discriminate against people in the minority. Gays would never get together and discriminate against heterosexuals. African Americans would never get together and discriminate against whites. I think that's sort of one of those things that's changed over the years. I think, you know, there are jokes in Hollywood about the gay mafia. There are jokes in other venues about the idea that, you know, people will band together and discriminate against others, even if they were at one time in the minority. So that may be why this change is coming around now, after this doctrine of special circumstances has been around for a long time.
Yeah, so the reality is there's a split of authority on whether a plaintiff in a reverse discrimination lawsuit regarding employment has to prove what they call special circumstances. Some circuits require plaintiffs in the majority, whites, men, heterosexuals, to prove special circumstances, while others, which is what you've been talking about, minorities, women, homosexuals, don't. The court's expected to address that inconsistency.
It is. And the court is expected to say one standard for everybody. You know, what are special circumstances? Well, if you have direct testimony, somebody saying, I hired this person and didn't hire this person because of this characteristic, that's a special circumstance. More subtle is, what if we have a quota? Or what if we have affirmative action? What if we have a desire to achieve a certain amount of balance racially between heterosexuals and homosexuals, men and women and the like? And the rule has been up until now, that's not you have to prove the existence of a quota, existence of special circumstances, and an African American or homosexual does not. And so that's what the court's expected to decide.
All right, and the court may not look at distinction. So the court has heard some oral arguments. Justice Amy Coney Barrett heard arguments and said, look, it doesn't matter if she was gay or whether she was straight. She would have had the exact same burden and be treated the exact same way under what we started with, Title VII.
Yeah, that's what she said, is that's what we should have is one single standard for everybody under Title VII.
And when pressed by justices on his defense of the lower court ruling in favor of the state, the Ohio Solicitor General, T. Elliott Gazer, he basically ultimately acknowledged that everyone here agrees everybody should be treated equally.
Yeah, that's why when they came before the Supreme Court, I think everybody was a little bit surprised that there was not a lot of disagreement on the significant major issue in this case. So the thought is this could be a 9-0 decision saying one standard across the country, nobody has to prove special circumstances, and Ms. Ames gets to go back to court and try her case.
Yeah, so one of the main reasons that the court's ruling is being closely watched is because it could lower the bar for people who belong to majority groups to bring reverse discrimination claims.
Yeah, and you know, even today, 20% of reverse discrimination claims are brought by white men already, trying to prove this special circumstance. So the idea is that if the court rules that there's one standard across the board, there'll be this flood of plaintiffs coming in. So what the argument was there was, well, look at the 5 circuits that require special circumstances, look at the 7 that don't, and is there more reverse discrimination cases in one than the other? And the answer was there was not a significant difference. So the floodgates will not be opened. But that's been one of the arguments, is if you take away special circumstances, there'll be a flood of reverse discrimination lawsuits.
So could the high court say basically, all right, let's kick this back to the lower courts for further litigation on whether Ames' case can move forward, or remove the background requirement altogether?
Yeah, I think the more likely thing is they're going to say there is no background requirement required, that she can prove her case by indirect or circumstantial evidence just as anybody else could who is not a minority.
So either way, yeah, in the end, will it just be a headline and make people more aware and not create a sea of change?
Yeah, I don't think it'll create a sea of change, because most of or half of the country is already under this no special circumstances burden. So it's only those people in the special circumstances jurisdictions in Chicago, Cincinnati, New York, San Francisco, and the like that are going to have this change. And for the rest of the country, it's not going to be any different.
All right, let's move on to the next high-profile case on the court's docket. Supreme Court's dealing with lawsuits against manufacturers and distributors of firearms. The government of Mexico sued Smith & Wesson, alleging that they are abiding and aiding and abetting Mexican cartels in obtaining firearms. It is a $10 billion lawsuit that Mexico filed against top firearms manufacturers in the U.S., alleging that the companies have fueled cartel gun violence. The question at hand, can Mexico actually bring such a case?
You know, this has some interesting background to it. Mexico basically has no right to bear arms. There's one gun store in Mexico. They've issued about 50 gun permits a year, so you can't just buy a gun in Mexico. Nevertheless, despite that, Mexico has one of the highest murder rates from firearms in the entire world. Only El Salvador and Guatemala exceed Mexico. So Mexico's argument is that the only way that our criminals get guns is if they're illegally imported from manufacturers in the United States. Therefore, these manufacturers in the United States should have to pay for all the medical expenses for anybody who is shot, the judicial costs of trying people who are tried for firearm charges, the cost of imprisonment, the effect that it has on our economy, and the fact that it's held back our structure in the nation. Huge damages. I mean, $10 billion might even be an underestimate when you look at all the damages that Mexico is alleging. So why did this case get brought in Massachusetts? You have to go back to the Sandy Hook school shooting case. The Sandy Hook case occurred in Connecticut, and they filed suit against Remington Arms Manufacturer because it was a Remington gun that was used in the school shooting. And after summary judgment was denied to Remington, Remington paid a $73 million settlement to the victims of the shooting. Congress came after that and passed a law that said, no, we're not going to permit you to sue a gun manufacturer just because their gun is used in commission of a crime. If their gun is correctly manufactured, correctly exhibits or expels a projectile, does what it is supposed to do, they're not responsible for the people who use the gun for illegal purposes. And so this act by Congress knocked out almost all of these lawsuits. This particular case was brought by the government of Mexico, not any individual who was shot, but by the government of Mexico, saying we need to be able to recover all these costs. And they didn't just sue Smith & Wesson. They sued Beretta. They sued Colt. They sued basically anybody in the United States who manufactures firearms that are used in crimes in Mexico. So the Massachusetts court came up with a decision that said, no, Congress, first of all, you really need to be suing the people of the United States, because it's the people of the United States who elect these congressmen who pass these laws, and it's the people of the United States who don't allow the gun manufacturer to be put out of business. It's really their fault, but Congress has spoken, and I'm only a judge, and I can't overrule what Congress said, so therefore I'm going to dismiss the suit. Case then went up to the First Circuit Court of Appeals sitting in Boston. The First Circuit said, well, they've got a little bit different theory. Their theory is that this is a Consumer Protections Act. that laws in Connecticut and Massachusetts protect consumers from dangerous products. A firearm is a dangerous product, and therefore we're going to let them proceed forward with this lawsuit, despite this congressional statute that says you can't sue a gun manufacturer. So that's really how the issue is framed right now. There are a lot of ways for Mexico to lose this case and very few ways for it to win. The very first, most question they have to deal with is standing. Can a Mexican government waive sovereign immunity, come into a U.S. court and say, you should apply Mexican law to our case in a U.S. court against these U.S. manufacturers and ignore what Congress has to say? If Mexico gets past the standing argument, then they have to get by the causal connection test. Is Remington, is Smith & Wesson, is Arboretta, are they really responsible if their gun works properly but is used by a criminal to commit a crime? And if they are they also responsible for the injuries that occur to the people and the economic damage to the country? So there are a lot of hurdles here for Mexico to overcome.
So if I'm to understand this, they're employing the simple argument that we've heard over and over again: guns don't kill people, people kill people.
Yeah, I mean, that's the thing they have to overcome, because that's a step too far in the chain of causation. Mm-hmm. In other words, nothing that the gun manufacturer did said that this gun, is going to be used specifically to kill people in Guatemala or Mexico or wherever it may be. In fact, the gun does what it's supposed to do. It ejects a projectile. And some people use it for lawful purposes, most people do, and a few people use it for unlawful purposes in Mexico. And that's one of the big arguments to be made.
All right, let's talk about the Mexican argument. An attorney from Mexico argues the case over economic harm, which you've brought up, linked to gun violence, is still in its early stages and should be allowed to go forward. Valid? From the Mexican government standpoint. You kind of touched on it, so let's elaborate a bit more.
Yeah, no, I think the fact is that before Congress passed an act that said, gun manufacturers can't be sued if their products work as intended, I think that they might have had an argument then, a common law tort argument. You created an unreasonably dangerous product. Your unreasonably dangerous product causes a lot of harm, and therefore you should be responsible for that harm. But once Congress steps in and says, no, we're going to pass an act specifically to do away with the gun manufacturer liability, with a majority of both houses of Congress and the president signing it, I think then Mexico has an insurmountable burden. The First Circuit Court of Appeals sort of threaded the needle, tried to give Mexico all the room it could to try to argue this is a Consumer Protection Act. Consumer Protection Acts apply to every single product used by a consumer, from defective soap to food adulteration to whatever. Nothing in the Consumer Protection Act says anything specifically about guns or firearms, nor was it intended to deal with guns or firearms being used in commission of crimes. But the First Circuit, by the way, a very narrow split decision. It went to the en banc, meaning normally a case is heard by just 3 judges in a circuit, and those 3 decide. After this went through the 3-judge circuit, it went to the entire 13 or 14 judges on the First Circuit, and they split with a 1-vote majority in favor of allowing Mexico to proceed. So it was a very narrow decision coming up to the Supreme Court.
Yeah, narrow on the lower courts, but what's interesting is that both the liberal and conservative justices on the Supreme Court seem skeptical that the claims could clear hurdles in the U.S. law. And we're talking laws that largely shield gun makers from lawsuits when their guns are used in crimes.
Yeah, and I think the position that even the liberal justices are going to say is, look, we're one of 3 branches of government. Congress makes the laws, we interpret and enforce them. And Congress has been very specific on this after the Sandy Hook shooting. They have said gun manufacturers simply cannot be sued. We're going to take jurisdiction away from the federal courts to even hear cases against gun manufacturers where the gun, in fact, works as it's intended to work. And I think the Supreme Court, even the liberal justices, are saying, yeah, okay, we understand our place in this tripartite system. We understand that we're here to interpret that law, we're here to enforce that law, or apply that law, but we're not here to change it. And therefore, under the separation of powers, we're going to give effect to Congress.
Right. Brett Kavanaugh, Justice Kavanaugh made an interesting point. He said many products from baseball bats to prescription drugs can be misused, and a flood of lawsuits could hurt the U.S. economy. That's a real concern, he says, I think, for me, about accepting your theory. He was talking about the theory floated by the Mexican government. What do you read into that?
Yeah, well, I mean, it's clearly what his opinion is. I mean, somebody else made the argument that this could be extended to Twitter. You know, if somebody uses Twitter or uses Facebook to propel or to put together a conspiracy, is Twitter now aiding and abetting the conspirators? Is Facebook aiding and abetting the conspirators because their platform was used for this? If you were to apply this same consumer protection rationale to virtually any product, there would be no insulation from liability by a statute like this.
You know, in going through the reaction from the other justices, I have to wonder if Ketanji Brown Jackson's response from the bench was a bit more telling. She said that the lawsuit ultimately seeks changes to the firearm industry of the kind that Shield law was aiming to forestall.
Yeah, that's true. And this is what we, talk about is regulating by tort or regulating by court. The court taking, doing away with what they consider to be a harmful product because of the fact they don't like it. And the district judge sort of acknowledged that. He said, we shouldn't, he didn't say this, but he implied we shouldn't allow firearms in this country. We shouldn't allow people to own assault weapons and other dangerous weapons. But the American people voted for this. You need to just, tell the American people they're wrong. They should get rid of these laws. But I have to deal with it. Congress passed this law. I don't have a choice. I got to enforce it. And even though I don't like doing it, I'm going to go ahead and strike your lawsuit and send you on to the First Circuit Court of Appeals in Boston.
And look, this suit has interesting context in today's environment. The arguments come as President Trump, his long-threatened tariffs against Mexico and Canada are aimed at, in part, on forcing the two U.S. neighbors to step up their fight against fentanyl and stopping illegal immigration. The Mexican government says, and you talked about the numbers, at least 70% of those weapons come from the United States. Lawsuit claims that companies' new weapons were being sold to traffickers who smuggled them into Mexico, decided to cash in on that market. You said there's only one gun store in Mexico, so that point has to be taken.
Yeah. The question, that point cuts both ways. Mexico has some of the toughest gun regulations anywhere in the world, gun restrictions and ownership. Nevertheless, they have one of the highest murder rates from weapons of any country in the world as well. So those people who argue that regulations don't work, the criminals will find a way to get guns one way or the other. If they didn't use American weapons, they would use Russian weapons. All of these arguments sort of come into play here. And the question is, who gets to decide? Is it Congress that gets to decide these issues, or is it the court that gets to decide them? And we're going to find out whether what the answer to that question is.
All right, so that brings us to the bottom line here. Last I checked, the Supreme Court seemed skeptical about Mexico's attempt to pass the buck to U.S. gun makers. You think it's going to block Mexico's attempt?
Yeah, I almost wonder whether they're going to get that far. They may actually say, Mexico, you don't have standing to even come to this court and make this case or bring this case because you haven't individually been injured. And then they wouldn't actually have to decide any of those other issues. They simply said, say the party who's here doesn't have standing to bring this lawsuit, case dismissed, move on to the next case. And a lot of times the courts like to decide things on as narrow a basis as possible, and that would be the narrowest possible ruling. This is to say, Mexico, you don't have the right. But then again, some of the people who get shot, would have standing, and they might come forward and there might be another lawsuit. Don't know.
All right, still to come here on Politics and Power, a national headache that has been a part of a decade-long dispute here to where to store nuclear waste. Supreme Court tackles a question before it brought by Texas landowners. That and more when Politics and Power continues. Welcome back to Politics and Power. I'm Bruce Hamilton with constitutional law expert Rod Sullivan. The Supreme Court will tackle a question about nuclear waste. The NRC is planning to send nuclear waste to Texas. Texas landowners are not happy and sued. The NRC says they lack standing to challenge the NRC's plan. It's much more interesting than it appears at the onset because it raises issues stemming from another case the Supreme Court ruled on not so long ago, Rod.
Yeah, and we talked about this on an earlier show, is that what's going to happen if the Chevron doctrine goes away. Now, most people out there have never heard of the Chevron doctrine. To them, the Chevron doctrine is you go to a Chevron station and get gasoline.
But it's something that we tackled, about a month and a half ago.
We did. We talked about it before because it's really been, in my opinion, one of the biggest sea changes in law in the United States. And, of course, you don't see it because most people don't deal with administrative agencies all the time. But let me just talk about what the Chevron doctrine did. The Chevron doctrine said if you, as an administrative agency, in this case the Nuclear Regulatory Commission, decide that under the act that created you, you have the authority to do something, we, the courts, are not going to second guess you on what the extent of your authority is. You're the authority on nuclear waste. We're not. Therefore, we're going to defer to your judgment. And that was the law up until a few months ago, 6 months ago or so. The Chevron doctrine has now been done away with. No longer will courts give deference to their own interpretation of what the statutes are. So let's talk about this case. And I've heard, I listened to some seminars where some people call this the Make Congress Great Again Act, because you and I have discussed the fact that Congress doesn't do anything and doesn't do anything significant that it's supposed to do.
And hasn't for a while. And
hasn't for a long time. So in 1954, we started having nuclear waste generated from nuclear power plants. 1954. So that's 70 years ago, 71 years ago. And Congress said, we're going to be like Europe. We're going to go ahead and recycle our nuclear waste, hold it at the plant until we develop a nuclear waste recycling facility in the United States, because the Europeans recycle their nuclear waste already. So that went on until the mid-1970s when Jimmy Carter became president. Jimmy Carter was a nuclear engineer. He said he didn't like the idea of recycling. He thought it was dangerous. So therefore, he said, we're going to create, I want you, first of all, I'm not going to recycle anything. I'm not going to even create recycling plants. I want you to figure out another solution. So Congress said, yeah, we've got a solution. Yucca Mountain. We're going to take a mountain in Nevada, we're going to hollow it out, and we're going to make it a permanent nuclear waste storage facility. We will never have this problem again. And we're going to spend $15 billion, B with a B, $15 billion, creating Yucca Mountain into a permanent nuclear waste storage facility. Now, the construction contractors, the employees, the construction workers in Nevada were fine with that. And they bent the $15 billion and they created the world's best nuclear material storage facility for permanent storage that was going to last 1,000 years. And the people of Nevada said, no, you're not going to, you might have created this thing. We might have gotten the benefit of it, but you're not going to put the first piece of nuclear waste in there. And there was a guy named Harry Reid who was head of the Senate, and he was able to block any waste from going into Yucca Mountain, passing through Nevada forever.
Wanted no part of it.
No nuclear waste has ever been stored at our $15 billion permanent nuclear waste facility. And this stuff, what is happening over the course of the last 70 years? Nuclear waste is piling up next to nuclear power plants. And of course, this is highly toxic stuff. It can be used to make dirty bombs and all sorts of things. So finally, a French company teamed up with an American company back in 2016, and they said, well, we know how to store, for an interim basis, nuclear waste, so we're going to seek a license from the Nuclear Regulatory Commission to create a consolidation facility in Texas and one in New Mexico, and we're going to get licenses to do that. And the NRC says, fine, we're going to hold hearings, and we're going to determine whether we can issue you a license to go to Texas or New Mexico. Now, the thing about Nuclear Regulatory Commission hearings is you can't just walk in. You're a citizen. You can't come in and say, hey, I want to know what you're doing, and I want to, I want to attend the hearings. Right, yeah. I want to know how you're going to store this stuff in the nuclear regulatory. This is national security. You can't know, okay? You might file written comments, but you're not going to be able to see what we're planning to do. So basically, the citizenry was totally excluded from the process, and they issued the permits. People of Texas went to their state. People of New Mexico went to their state, and 3 lawsuits were filed. One was filed in New Mexico, one was filed in Texas, and one was filed in the District of Columbia, all of which said the same thing. You, the NRC, do not have authority to issue permits to store nuclear waste in our state. And there being 3 different courts, you know how many opinions they came out with? They came out with 3, okay? Texas, the court that heard the Texas case was in New Orleans, the Fifth Circuit. They said, No. Congress has created a comprehensive scheme for the storing of nuclear waste at Yucca Mountain. You, the Nuclear Regulatory Commission, don't have authority to issue a license for this consolidated interim storage. By the way, you know what the word interim means in consolidated interim storage?
And herein lies the argument.
40 years!
Yeah.
I mean, after you're all dead, those licenses will expire. And then the court in New Mexico and the court in D.C. said, well, you didn't participate in the hearing, you citizens from New Mexico, and therefore you don't have standing. And they say, we couldn't participate in the hearing. We didn't have national security clearance. We didn't know what was going on.
You weren't going to allow us to be there.
Yeah. And the D.C. Circuit says, hey, they're a regulatory agency. They can do whatever they want. We're going to say hands off. So you got 3 courts with rulings in this case, and now it goes to the U.S. Supreme Court.
All right, let's talk about that word interim. The big issue for the court seems to be how temporary the storage would be. Aaron Nelson, the Solicitor General of Texas, told the High Court during arguments that if the justices believed the off-site storage would be a temporary fix, then, quote, I have a bridge to sell you.
This nuclear waste has been sitting outside of nuclear power plants for 70 years now. They're giving a 40-year license. It's not going to be temporary. It's not going to be temporary until Congress steps forward and does something. And this is going to, this is probably going to throw the ball back in Congress's court and say, you're going to have to decide what it is. We're not going to let the NRC, pass this ball down to the next generation. And I think that's what the justices are looking at.
Yeah, you pointed this out. The Commission's license to interim storage partners allows it to house nuclear waste for up to 40 years, and that license can be renewed. Now, even some of the justices are skeptical of their temporary interim nature. Neil Gorsuch said, a license of that duration does not sound very interim to me. And he said, I think this is key. He hopes we won't have radiated oil and gas. So that brings up another big issue. The waste can remain radioactive and pose health risks for thousands of years.
Yeah. Yeah, it's funny, we've got such a dual system because Europe has nuclear waste, Japan and Korea have nuclear waste, and they're all using recycling. They transport their nuclear waste across rail lines, across roadways, and they have successfully done this for more than 50 years. We in the United States are just backwards on it. We are the farthest behind when it comes to deciding what to do with our nuclear waste.
Why?
Because of Congress, because Congress doesn't do anything.
Because it's bass backwards.
Yeah, I mean, you have politics getting in the way. In other words, Congress is okay spending $15 billion on a nuclear waste storage site that's permanent. They just don't have
they won't use.
What's that?
That they won't use.
That they won't use because influential congressmen and senators in Nevada, New Mexico, Texaco will not allow them to either transport or use the facility. So that's why people are calling this the Make Congress Great Again Act, because if the Supreme Court says, NRC, you don't have authority to issue licenses, Congress is going to have to do something, or it's going to continue to pile up alongside nuclear power plants.
All right. You're right. Going to continue to pile up. What kind of numbers are we talking about? Roughly 91,000 metric tons of nuclear waste from commercial power plants are currently in private storage, both at or away from nuclear reactor sites. That's according to the U.S. government. And with nearly 20% of the nation's electricity supplied by nuclear energy, plants are generating an additional 2,000 metric tons of spent fuel each year. That's an estimate from the Energy Department. Complicated politics has gotten in the way of addressing the problem since the advent of nuclear power last century. Is the real worry for the court here about safety and lack of progress toward a permanent solution? I think we've answered that question.
Yeah, but I don't think the court is actually looking at that. I think the court is looking at powers. Who has the power to decide this? And with the pressure of climate change, we've used all of the hydroelectric power facilities we can use. We just don't have any more rivers, any more lakes, any more mountains to create any more hydroelectric power. So that is pretty much done with. So the question, and the other power source that we have is natural gas, and we have coal and the like, and then we have solar and wind power. So nuclear power, to the eyes of a lot in the environmental community, is the only answer to a bad question, because you get nuclear waste, but you also get carbon-free energy coming out of nuclear power plants. And if you look at the stocks of nuclear power company manufacturers, Genova, Oklo, and companies like that, they are going through the roof. Because the thought is that the people in the environmental movement are only all of a sudden going to say, look, we're not going to be able to do it with solar, we're not going to be able to do it with wind, nuclear is the only answer, and therefore we're going to stop standing in the way of new nuclear power plants, and that we're going to have more nuclear power plants in the future. It's always been a Hobson's choice for people. You know, you get nuclear waste, but you get carbon-free power. Am I willing to make that compromise to have, you know, a cleaner environment, no more carbon dioxide being put in the atmosphere? Can you operate electric cars without a significant source of carbon-free power, meaning nuclear? So that's going to be the issue that Congress is going to have to deal with.
I mean, if Congress isn't going to make the decision, Congress has to, or if the courts have to decide who has the power to make the decision, why can't the court?
Well, I mean, the lower courts, particularly the Fifth Circuit, said, look, there's something called the major questions doctrine, which has come up in the last few years. And the court has said, Congress has spoken to this issue. Congress created a permanent facility. Congress funded a permanent facility, and therefore they have, by implication, not given the Nuclear Regulatory Commission the right to issue storage permits. The right to store nuclear waste belongs not with the Nuclear Regulatory Commission, but rather with the Department of Energy. And therefore, their argument is very similar maybe to the gun control argument is, once Congress has spoken, it's not up to us to resolve the issue. Congress has spoken. There is a permanent waste disposal site at Yucca Mountain, and it's up to Congress to see that that's enforced, and not for the NRC to do an end run around Congress to create these quote-unquote 40-year temporary facilities.
So nothing's going to get done.
I don't know about that. I mean, we have all of these court decisions where they're telling Congress, you're responsible. It is your job to do this.
Congress isn't responsible.
Congress has never been responsible, but you never know, you know? Hope springs eternal that someday people are going to get in Congress and say, look, Democrats, Republicans, we can agree on at least this. We don't want nuclear waste sitting outside alongside nuclear power plants.
Look, we've got do-nothing Democrats. We've got a GOP that lies through their teeth. I don't know.
You're not hopeful.
No, it's an absurdly difficult problem the court is wrestling with. A decision's expected by late June. Tough to say where they're going to go.
Well, you know, if anything the last, month or two has shown us that revolutionary change can happen really quickly. Was it Marx or Lenin that said sometimes change takes 20 years and sometimes it takes 2 weeks? And maybe we will see this, a quick action by Congress to finally take the braces off of nuclear industry and say, take it to Yucca Mountain and put it there, and we don't want to hear anything else out of you, Nevada, about not wanting nuclear waste in your state.
Don't have a crystal ball, but we do know that things change.
Yes. Rod,
always a pleasure. I appreciate you.
Enjoy it.
Remember, you can watch Politics and Power on demand anytime on the News4Jax YouTube channel and news4jax.com. Appreciate you. Have a great day.
See why every day more people are choosing News4Jax, Northeast Florida and South Georgia's #1 source for local news.